It's been a busy day at the judiciary as the highest court in the land puts finality to the election victory of 8 governors in the country. Well, after months of legal wranglings, these governors can now heave a sigh of relief. But then, the bigger job of governance lies ahead. And the 37 billion naira controversy rages on. The amount said to be for the renovation of the National Assembly has got Nigerians asking questions. And we seek to unravel the facts behind the figure tonight and answer some questions on the minds of Nigerians. Hello everyone and welcome to the program. This is Politics Today, live on Channels Television. I'm Kayode Okikiolu. Well, 8 governors can now heave a sigh of relief now that the Supreme Court has affirmed their elections after they were challenged at the election petition tribunals. The governors are Lagos State Governor Babajide Sanwo-Olu of the APC, Governor Seyi Makinde of Oyo State of the PDP, Engineer Dapo Abiodun is the Governor of Ogun State of the APC, Nasarawa State Governor Abdullahi Sule of the APC, as well as Governor Nasir El-Rufai of Kaduna State, also of the APC, and Governor Aminu Masari of Katsina State, of course, is of the APC. Well, more governors, Akwa Ibom State Governor Udom Emmanuel of the PDP, and Governor Dave Umahi of Ebonyi State. He represents the PDP. So let's walk you through what happened in some of the cases. Well, in the case of the Oyo State Governor, the judges found merit in the appeal, which was filed by Mr. Makinde, that the majority judgment of the appeal court was a miscarriage of justice. In its place, the court affirmed the majority judgment of the election tribunal, which upheld the election of Mr. Makinde as the duly elected governor of Oyo State. Let's move over to the Kaduna State case. On that suit challenging the victory of the state governor, which was filed by Issa Ashiru of the People's Democratic Party, the judges ruled that the application is lacking in merit and therefore dismissed it. Well, more, the suit challenging the victory of Mr. Abdullahi Sule also suffered a similar fate as the judges ruled that the applicant was unable to prove to the court the allegations of substantial non-compliance in the election. The governors of Lagos, Ogun, Katsina and Akwa Ibom states also got the Supreme Court's nod, affirming their victories as the suits of their challengers were struck out for lacking in merit. So that's it. It's final. It's done. No more uncertainty, and it's expected that the work of governance, which is ahead of them, will be faced squarely. And speaking of governors, the Nigerian Governors Forum, of course, Nigerian governors in the country under their ages are expected to meet later tonight. Apparently, a lot of issues are meant to be on the table. But at the time of speaking with the spokesperson of the forum, Mr. Abdulrazak Barkindo, details of the agenda for the meeting were still unknown. But expectations are high, as expected, that restructuring debate, security, and the state of the economy, particularly the issues of minimum wage as it affects the state, would form part of the discussion. The meeting is expected to begin any moment from now, so stay with Channels Television to get the latest updates from that meeting. So let's now bring you some other stories we're following for you on our political roundup.
The Edo State High Court, sitting in Benin City, the state capital, has held that it has jurisdiction to entertain the suit filed by Anselm Ojezu and 2 others against retired Colonel David Imuse and 2 others with regard to the leadership of the All Progressives Congress APC in the state. The court also dismissed the defendant's application seeking to set aside the interim injunction granted the claimant on the 22nd of November 2019. Parties to the suit are also to maintain status quo pertaining to the interim order pending the hearing of the interlocutory injunction fixed for January 13, 2019. Akwa Ibom State Governor Udom Emmanuel has signed into law the 2020 budget of 597.735 billion naira, with the figure showing a reduction of 65 million naira from the earlier figure proposed by the executive. The governor promised to work passionately in ensuring the strict implementation of the budget for the benefit of every citizen of the state. The Kwara State Governor Abdulrahman Abdulrazak has presented the 2020 budget estimate of 162 billion naira to the State House of Assembly, with provisions for critical infrastructure and human capital development taking the larger chunk of the budget. Tagged Budget of Reconstruction and Reformation, the governor says the fiscal plan comprises 53% capital expenditure covering road construction and rehabilitation and re-equipment of schools and hospitals, with 47% recurrent expenditure and 53% capital expenditure in a deliberate attempt to invest in the future and grow the economy through critical infrastructure and human capital development. Nigeria is set to hold a national policy dialogue which will provide a blueprint for the attainment of sustainable development goals by 2030. A high-powered presidential delegation on SDGs intimates the governor of Bauchi State on plans while paying a courtesy visit on him. Governor Mohammed has been nominated to receive an award for efforts being made by his government to promote and implement SDG programs. The elected governor says the award will stimulate him to work harder in addressing the multi-sectorial challenges in the state.
Tonight begins in the Supreme Court's judgment which affirmed the election victory of 8 governors across the country. So let's get more reactions to the judgment, the electoral process that led up to the tribunal, that now led up to this judgment, and other issues in between. And we're being joined by legal practitioner, Mr. Ofoneme Eno. He joins us from our Abuja studio, as well as Mr. Eze Onyekwere. He's the lead director, Center for Social Justice. Thank you so much for joining us tonight, gentlemen.
Thank you very much.
You're welcome. So let me begin with Mr. Onyekwere. First, I'd like to get your reaction to this judgment. Some have described it as landmark judgment. I mean, for 8 governors, that's a lot. So how do you respond to this judgment first?
Well, let me start by saying the Supreme Court has ruled and are final under jurisprudence. But then if you look at the Electoral Act and the jurisprudence that have emerged, it's more or less a very big hurdle for any challenger to be able to get his way up through and get a victory through the judicial system. So a very big hurdle was presented before them, and then more or less 8 of them have been affirmed, more or less representing the status quo. But Nigerians complained a lot about the things that happened in the elections. And then this affirmation is just a call to duty that electoral reform should take place, and then Nigerians should be more observant, and things have to happen in a much more civilized manner in future elections. So beyond the reaffirmation, it's just a call to duty. That's the way I see it.
Right. Now, before I come to some of the issues you raised, Mr. Onyekwere, let me get Mr. Eno's reaction to these judgments, 8 of them. So, Mr. Eno, what are your thoughts?
Well, to begin with, congratulations are in order to the 8 governors who have scaled the final hurdle at the Supreme Court. I think it lays to rest the issues that began with the primaries, and I think it's time for them to concentrate on delivering on the mandate that was bestowed on them. But beyond that, the issue of electoral reforms, administration of electoral tribunals, and also the issue of technicality has reared its head. If you look at the analysis of this judgment, you realize that majority of them were ruled based on the inability of the challengers to actually present their case and match them with the irregularities that they allege to have been there. We also have seen also that there's really not been a concentration on the actual substance of the electoral malpractices or election rigging, like as it was alleged. So it brings to the fore the issue of electoral reform and also the need for our National Assembly to take into consideration the review of the Electoral Act to incorporate some of the issues that have been brought up both at the tribunal, the appeal, and the Supreme Court level. But beyond that, I think the big picture is for these governors, the 8 of them, to accept this verdict and move on with the task of delivering on their electoral promises to the people that voted them.
Right. It appears so far both of you have agreed on electoral reform. So, Mr. Oyekpere, you highlighted some things earlier, which I'd like you to shed more light on. You said that the Electoral Act, as it stands right now, makes it hard for an opponent, for example, to upturn the election result. And you say that there are really major hurdles to cross, and it makes it really difficult. So if you could shed more light on that. How so?
Yeah, very well. I think if you look at what the courts have decided over the years, they are talking about electoral cases being sui generis. Sui generis in the sense that you've got to prove a whole lot of things, particularly when you allege that a crime has been committed. You don't just have to prove that there are malpractices, but that those malpractices substantially affected the conduct of the elections and the result in such a way that it could not have represented what the voters actually cast at the polls. So, based on the presumption of regularity for official acts and conduct, you are just loaded with a lot of things stacked against you. And then the jurisprudence has to change based not just on what the Electoral Act presents. The Electoral Act will need to be amended, but as well as the attitude of the justice towards electoral jurisprudence. They don't have to be conservative. I think the central question should be, what was the preference of the voters in the election? Who did the voters choose? Because democracy is about one man, one woman, one boy, one girl, one vote. And it's about the mandate of the people for somebody to lead them based on their preference of whatever he had promised them in his manifesto. So if you move away from there and just go on a voyage of discovery to technicalities, you are not doing justice. You are simply playing to the gallery, you are simply being lauded, and you are simply going beyond the mandate that was given to you as a judge. You are simply trying to take away the rights of the people by refusing to inquire into the ultimate jurisprudential question of who actually did the voters select. That should be the central question in every jurisprudential analysis, in every court judgment about electoral victory or not. It is not about technicalities. Any judge deviating from this idea of who actually did the voters select is on a voyage of discovery. Whether it's at the Court of Appeal or the Supreme Court, this is just the ultimate justice. It is not about what you think as a man or woman. This is the justice every man or woman will like to be delivered to him. And I dare say, if the Supreme Court deviated from this, they were on a voyage of discovery.
Right, Mr. Oyekpere, now some would say that each party, I'm talking about, both parties in this case, for example, have, equal time, equal opportunity to prove their case. So it's not as though the judgment will be tilted to one side, since everybody comes with their evidence and counter evidence. So you still feel like it's still kind of lopsided. How so?
No, what I'm saying is the jurisprudence that has been on in Nigeria for so many years. The jurisprudence that fails to ask the critical question, who did the voters give their mandate, right? As against looking at technicalities that does not really touch on that issue of who actually won the mandate of the voters. So when you decide on technicalities without looking at who actually won, who the voters actually express their preference for, then it is just like leaving something that is on the road, entering the bush. At the end of the day, you declare, but because you are the final court, or because you are the Court of Appeal, or because you are the tribunal, whatever you say constitutionally is the law, so it remains. But the people who are paying you, the taxpayers, the citizens, the ultimate sovereigns, may not be happy with your decision. And until we get away with that jurisprudence of not deciding on the merits is who got the majority of votes, lawful votes, in every election. Any other thing is just not it.
All right. So, Mr. Eno, the term technicalities has been used a lot. And I know I'm speaking for a few Nigerians who wonder, what exactly does this mean? How does this apply to judgment? So if you can help us understand this, how do technicalities come into play? And why do you think Mr. Oyekpere is really talking about it?
All right. Technicalities, it's a term in legal practice, which means that before any issue is brought, it has to follow its procedural rules. So in the Election Petitions Tribunal, for example, before the subject matter is being heard, there are certain procedures that must be complied substantially before the crux of the matter is being heard. So technicality has been an issue in electoral tribunals right from the inception of democracy. And over the years, the electoral reforms has tried to attack and deal with this issue, one of which has been the move to keep pre-election matters in regular court and then post-election matters in the tribunal. There's also been a move to shorten the limit of time within which an election petition should be dealt with to allow for the elected officials to concentrate on the business of governance. Now, beyond that, we are faced today with procedural issues which has to do
Mr. Eno, I know you're taking us to the classroom. I'd like you to continue in a moment.
All right, so like we were saying, it's not, actually it's not a lecture, it's just analyzing the issues as they come. We've been faced with the issues of tendering of documents, admissibility of documents, and also witnesses, the amount of witnesses to be presented, and what we'll call credible witnesses. It's a high time that the issue of electronic voting, electronic accreditation of voters, to make the job easier, to be considered in terms of electoral reforms. So therefore, so that judges and lawyers alike will be able to have access to these materials. We have to also look at the issue of forensic analysis in terms of analyzing accreditation of voters vis-a-vis the number of votes being cast in every particular polling unit.
So let's rejoin our guests in Abuja. We still have Mr. Ofoneme Eno. He's a legal practitioner, as well as Mr. Eze Onyekpere, a lead director for Center for Social Justice. Gentlemen, thank you so much for your patience. So, Mr. Eno, I'd like you to land now on your talk about technicality and, what this means to the adjudicating process and what we have seen so far, if you may.
Well, in summary, for our electoral reforms to really have an impact in the administration and conduct of elections in Nigeria, there is an urgent need to revisit the election reforms bill, which wasn't assented to by Mr. President prior to the last election due to the lack of time within which an electoral act should come into existence and this proximity to an election. I think it's high time that Mr. President, thank God that he said he's going to look into electoral reforms yesterday when he was celebrating his 77th birthday. It's high time the National Assembly should revisit the Electoral Reform Act with specific concentration on the issue of electronic accreditation, electronic transmission of votes cast towards the central server. It's going to aid, one, in credibility of the electoral process, and also it's going to eliminate reliance on a lot of technicalities in terms of presentation of documents and admissibility of evidence. There is also ancillary legislations like the Evidence Act, the Administration of Justice Act, and other ancillary legislations should be looked into to be able to expedite the electoral process. Also, there may be a need in the future to consider the creation of specialized election petition courts, which would identify and only deal with election petition cases. This is to hasten the course of election tribunals administration. I think these reforms may be taken into consideration or should be taken into consideration by the National Assembly and Mr. President moving forward.
Right. Now, Mr. Oyekbere, another concern, just to add to what Mr. Eno has said, is the uncertainty, that is attached to that period of, going to the tribunal, goes to the appeal court, then the Supreme Court. I mean, from March up till this moment. So on one hand, is there an argument, that centers around the fact that this might distract, the governors from the work of governance on one hand? And how can we bridge that gap such that we don't have issues dragging for this long? I imagine that the judgment went the other way. It will have upturned a lot of things. So how do we bridge that gap?
Well, if you have been following the election petition cases in Nigeria, there was no time limitation before, but happily, the Constitution has been amended several times, and there are time limitations. So if you finished a matter, you had elections in February, and then by December, you've gone through the Election Petition Tribunal, you've gone through the Court of Appeal, you've already gone through the Supreme Court. I think you cannot abridge it further, because some of us are even wondering whether the time frame that was abridged before was properly abridged, because the abridgment happened under the normal constitution amendment procedure. And if you consider what was abridged, it was the right to fair hearing that was abridged. And I remember the senior advocate, Mr. Hamba, had gone to court to say that the abridgment process of the right to fair hearing and other fundamental rights required a certain supermajority, which was not just part of the normal constitutional majority for amending the constitution. So there's absolutely nothing you can do about that for now, because that's not the challenge. The challenge should be just about electoral reforms. Beyond the server and ICT issues, there should be accountability and transparency. So as you're even moving from the polling unit, you count the number of people that came, you count the number of people that voted. It should be available to all and sundry that has been there. And even in the website or the server you are pasting, it should be available for everybody to go in and check before it gets to the national center, where everything is accumulated, and then you tabulate everything, so that people at the local level can now begin to say, if the results you announce at the national level is not right, they say, no, this is not what we delivered at the local level. And beyond that also, we need agencies of government to begin to take themselves seriously, like in matters of political finance. We have the police, we have the EFCC, we have the ICPC, we have the NFIU. We were all live on television when Bola Tinubu carried the bullion vans, and EFCC pretended they didn't see. ICPC pretended they didn't see. Even by his confession, there could have been crimes committed. So we must get beyond simply technicalities of laying down things in law and begin to take ourselves seriously as Nigerians, because we can't continue on these shenanigans if we want Nigeria to make progress.
Right.
If we want to continue with underdevelopment, great and good. Because I've always challenged Nigerians to tell me one country run by black men and women in the world, beyond our postulations about slavery, colonialism, neo-colonialism, that is doing well,
right,
that is manufacturing things, that is producing things. We can't continue pretending the world is waiting for us. The world is not waiting for us. Okay? So I am insisting we must have reforms. If we don't have reforms, we will perish.
Absolutely. So, Mr. Eno, earlier you mentioned the president's statement about him saying he wants to oversee a free, fair, and credible 2023 election. Now, that statement for a lot of people carried weight, but then they expected that action would follow. So if you could outline some of the actions that should naturally follow a statement such as that, what will they be for you that will show seriousness?
Well, considering the doctrine of separation of powers, the first move I think Mr. President should take would be to revisit the Electoral Reforms Act initially presented to him, either by calling for a fresh accent or incorporating his ideas of reforms into it and presenting it again to the National Assembly. This particular National Assembly seems to have a good working relationship with the executive. So I think, considering how fast the 2020 appropriation bill was passed into an act, I don't see any difficulty in all subsequent bills between Mr. President and the National Assembly. That's step number one. Step number two would be for Mr. President to show leadership by allowing the institutions of the state that are saddled with the responsibility of ensuring proper electoral process to carry on their duties, and offenders should be punished decisively. There are a few more states which elections will be coming up between the lifetime of Mr. President's second term. How that elections will be managed will determine to a large extent how serious and how determined his resolve to leave behind a free and fair and credible election. We are looking forward to the elections in Edo State, and considering the issues and the drama that has surrounded the present state of affairs in that state, one would take a critical look on how the institutions of the state, saddled with the responsibility of overseeing an election, will carry on their duties. These institutions are largely under the executive, and so Mr. President would have to, beyond mere rhetorics, show leadership and direction. He would also have to use the instruments of the law to ensure that our electoral reforms stand the test of time. This is the only country where, this is a country that should follow the trend of incorporating ICT, information technology, into our electoral processes. We have if you go to the polling units to vote, you are accredited using the card reader, but the law does not recognize the card reader. So the card reader is an administrative instrument of INEC, not necessarily recognized under our laws.
Okay.
These things should be incorporated. And like I said, I've also mentioned the issue of a special election petitions tribunal.
All right.
To oversee the conduct of elections so as to distinguish between the regular courts and the election petitions tribunal. Beyond this, like my co-panelists have said, there is the issue of leadership. There is the issue of governance.
Mr.
There is the
Ofoneme,
issue of leaders at all levels,
you know,
from the
I
local
understand.
government to the state, to the president, to the federal government, to take responsibility.
Right.
And
I
show
understand.
that leadership is not just about elections, but providing what they promised to the people.
I understand that this is a major topic for discussion, and I appreciate the vigor you have given to it. But I'd like to thank you so much, Mr. Ofoneme Eno. He's a legal practitioner. He joins us from our Abuja studio, as well as Mr. Eze Onyekpere, the lead director, Center for Social Justice. Thank you so much, gentlemen, for sharing your thoughts for the development of the nation.